How to prepare for a medical deposition. I'm Dr. Sandy Sambar. During your career as a physician, you will most likely be asked to undergo a deposition during the discovery phase of a trial. The case may involve an auto or motorcycle accident. It may be a personal injury case. It may be premises liability or a workers' comp injury. It may be a hospital or medical malpractice, or it could be nursing home abuse or a product liability case. No matter what the case is, this can be a stressful time during any lawsuit, especially in a medical malpractice case. Most physicians are unsure what to expect. What are some things you need to know about a medical deposition so you can adequately prepare? Well, the first thing is, what is a deposition? Well, a deposition is basically involves providing testimony under oath, much like you would during actual courtroom legal proceedings. It is performed to find out what you know about the case and to preserve testimony for trial. This is important because it allows both parties to learn as much information as possible before the court date. This, in turn, allows each party to review the strengths and weaknesses of their opponent's case. This also makes it more likely to arrive at a fair settlement, if that is possible. The physician may be an expert witness, or could be a defendant, or at times a plaintiff in a case. Regardless, that physician may have to be deposed by opposing attorney. Well, during the deposition, the attorneys for both sides are present, and expert witnesses may also be present depending on the exact nature of the claim. But the physician who is being charged with negligence has the right to attend a medical malpractice deposition. There is a process for the deposition. The deposition will not take place in a courtroom. Instead, it will be held in a mutually accessible area, such as an attorney's office. It will be transcribed by a court reporter, and the court reporter will also be responsible for swearing you in as the physician. The deposition process begins with what is known as the direct examination by opposing attorney. Here, the opposing attorney will ask the physician a series of questions. The person who is being deposed is referred to as the deponent. During the direct examination, the deponent must answer all questions truthfully. If the physician does not understand a question, ask for clarification. Otherwise, you as the physician will be deemed to have understood the question, and your response will be noted accordingly. After the opposing attorney has finished examining you on direct, your attorney will then have the opportunity to cross-examine or ask you other questions. In most cases, I should say, during the deposition, cross-examination is limited only to questions that directly pertain to those asked during the direct examination. Once cross-examination has taken place, the opposing attorney will again be allowed to ask more questions, and this is known as redirect examination. The deposition ends with your attorney following up with more questions, which is called a re-cross examination. Your attorney may object to questions at any time during the direct or during the redirect examination. Even so, these objections are somewhat different than they would be in a courtroom, as there is no judge present during the deposition. As such, objections involving the federal rules of evidence, particularly hearsay, are not normally made. Should there be extreme harassment or humiliation from the opposing attorney, well, your attorney may ask for the deposition to be terminated early. This must normally be approved by contacting a judge. So keep in mind that the odds of this happening are very slim. Even if things become harrowing, you should do your best to remain steadfast and unshaken, as doing so will help establish you as a strong and confident witness who is likely to be convincing to the jury. Let me turn to the rules of civil procedure that govern depositions. The rules governing depositions are spelled out under Rule 30 of the Federal Rules of Civil Procedure. Some states have similar procedural guidelines as well. This Rule 30 requires the deponents to be notified in writing, to include being informed as to the method of recording, whether by audio or video. The rules limit the number of depositions each side may conduct, and the rules restrict how long a deposition may last. Generally, no more than 7 hours per day for each deponent. Rule 30 of the Federal Rules of Civil Procedure also cover what is called subpoena ducis tecum. What this involves is a request to produce physical evidence. As such, you could be required to bring certain documents with you to the deposition. Your attorney will explain what these documents are so you can be sure you are in compliance. It is a good idea to give your attorney copies of any documents you plan to submit ahead of time so that he or she can review them prior to the deposition. That way, your lawyer will have better information concerning the type of questions you might be asked and will therefore be better able to prepare you. Now, let's move to your appearance as a, let's say, defendant. If you're a defendant, your appearance is mandatory. In a case of medical malpractice, depositions are an essential part of discovery. Thus, the attendance or appearance of the defendant physician is mandatory. The physician will likely receive a subpoena from a judge noting the date, the time, and the place of the deposition. Should you fail to appear, the defendant may petition, the opposing attorney may petition the court for recovery of any expenses incurred as a result. This may be a number of sanctions that may be imposed by the court for failure to appear. These sanctions can also be applied if the physician fails to produce documents as required. As the plaintiff patient, if you look at what they're supposed to do, they may be required also to attend the deposition, and that happens more often than not. That's because the patient could be in a state of declining health, and their deposition would be taken in order to preserve the evidence. In this case, the deposition may be the only chance a patient has to make as far as their symptoms or what's happening to them in order to be used in trial, should they not be able to do so. Well, how do you prepare for the deposition? Depositions are transcribed and put into writing or electronic format that can be reviewed by any time. Statements that are made during a deposition may later be used to impeach one's testimony at trial. If a deponent subsequently gives conflicting testimony in court, attorneys could refer to a statement that you made during your deposition in order to make your credibility seem questionable. Since having your testimony impeached could be detrimental to your case, it is important to properly prepare ahead of time to prevent this from happening. Your attorney will play an important role in helping you prepare for a deposition. Some of the things that the attorney might do to guide you in preparing are having you review documents a day or two before the deposition to jog your memory. Another thing would be talking with you about key events to allow you to better focus your attention on the exact act of alleged negligence. Third, the attorney will be giving you some sample questions that may be asked by the opposing attorney. And the attorney may remind you of proper etiquette and advising you to give short, concise answers to questions. Some attorneys will even provide mock depositions or mock cross-examinations as a part of their preparation. And interestingly, during a mock deposition, your lawyer may ask difficult questions. The attorney may become harassing at times or appear to take personal jabs at you. This is not unusual. What the attorney is trying to do is to train you how to handle this situation of behavior from the opposing attorney. So during the preparation phase, you may also be given a sample medical malpractice deposition to review. You may be given a link of a deposition of a physician that is published online. This sample deposition will give you a better idea as to how the actual deposition will proceed. It will help you visualize how it may be used to evaluate your case once it is completed, once the deposition is completed. So you may want to read some sample depositions performed on attorneys so you can picture some of the questions you may be asked as well. Some attorneys prepare what is called deposition outlines. Attorneys often use medical deposition outlines to help guide them in the process. An outline will lay out the facts about the case and will list certain subject areas to cover. The outline may have a checklist for an attorney to use to stay organized. The deponent will not have access to the outline by opposing attorney. However, your attorney may be able to provide you with a sample that will give you a better idea what to expect during questioning. Keep in mind that outlines for medical malpractice depositions are often very specific and may change, though, a great deal as well. And let me give you some common medical malpractice questions that may be asked. Your deposition will normally begin with a few personal questions, such as, what is your address? What is your name? Where do you work? How long have you been employed or working? How old are you? Are you married? What is your spouse's name? And so on. These questions are asked so that the opposing attorney can get to know you a little bit better and know about you. That way, it will be easier to assess how well you will perform as a witness during trial. These questions are used to make you feel more comfortable in the beginning, so that you will be more likely to let your guard down and give information more freely. Be mindful of this so you don't fall into this trap. When it comes to the real facts in a medical malpractice deposition, many of the questions that are asked will be repeated. They'll be asked over and over. And let me show you some of the questions that the defendant attorney, your attorney, will ask the patient plaintiff. When did you first notice symptoms of whatever the problem is? Did you seek help immediately? Why or why not? What instructions were you given after medical procedure by Dr. So-and-so? Did you follow those instructions to the letter? Why? Why not? What complications did you suffer as a result of medical procedure? What care have you received since the injury occurred? Are you currently taking any medications? If so, what are they? Have you been advised to have any other surgeries or tests performed? If so, by whom? Have you obtained a second opinion for your condition? Why do you feel the doctor was responsible? How has the injury affected your quality of life? What is the prognosis for the future? The physician deponent is asked similar questions, but they pertain to the patient's medical care. When the plaintiff patient or the physician deponent is not sure or do not remember, they are advised to say, I don't know, or I don't recall. If the plaintiff or the doctor does not remember events, but are not quite sure about exact details, they are advised to say, to the best of my knowledge, or as far as I remember. Should one later determine that the defendant has made an incorrect statement, it is best to clarify it, if possible, before the deposition ends. But if one realizes the incorrect statement after a deposition is over with, then it is best to notify the attorney immediately so that the proper steps can be taken to officially correct the testimony. Since a medical malpractice deposition is a little less formal than a court trial, attorneys will sometimes intentionally badger witnesses in an effort to rattle them. It's important to maintain your composure throughout the deposition so as not to fall into this trap. Now, let's look at some malpractice deposition advice. While undergoing a medical malpractice deposition, this may be excruciating. Nonetheless, there are some things you can do to ensure that your deposition is a success. Be on time and be sure to present a professional appearance. Your first impression means a lot, which is why you should be neat and well-groomed when you arrive. You should also know your case. But don't make up facts in order to fill in gaps. Remain confident and avoid becoming angry or making derogatory statements against anyone. Rehearse ahead of time with your attorney or even at home with a friend or a family member, and avoid overstating the case. Stick to the facts. So what happens after a deposition? After a medical malpractice deposition takes place, the court reporter will then transcribe the event and make the results available to both parties. Depending on how long the deposition was, this could be anywhere from a few days to a week or two or longer. But once your attorney receives the deposition, it will be reviewed and then notes taken about the strengths and weaknesses of your case. Finally, a word about deposition. The medical malpractice cases are rarely settled immediately after a deposition. Instead, they may proceed for several months or even years before the offer is made. Some are not settled until just before the trial commences. As such, it's important to prepare as though you are going to trial, since a settlement is never guaranteed. It's also not uncommon to receive a real low settlement offer initially. The results of the deposition will prove invaluable when trying to determine whether one should accept to settle or not to settle. So making a settlement in a malpractice case is extremely complicated, as there may be multiple healthcare providers named as defendants. The nature of the injury may also be very complex, requiring quite a bit of discovery in order to make an accurate assessment. Then there is the medical malpractice insurance companies. They are involved, so there are a number of parties that must communicate with one another before a settlement can be reached, if needed. And thank you